Namaskar, brothers and sisters, ladies and gentlemen, students and scholars, teachers and trainers, professors, professionals, respected doctors and directors, honorable ministers and managers, honorable advocates, advertisers, administrators and advisors, the most honorable President Mr. Modi ji, I heartily, cordially welcome. It is really nice time, nice place, nice session today that we are defining, explaining, describing our holy Indian Constitution, which was designed by, written by, prepared by Baba Saheb for the welfare of the downtrodden, rejected, poor, needy, all persons are equally treated and accepted according to our Constitution. There is no discrimination on the basis of caste, color, creed and language. There is no doubt India is the land of multidimensional, multifaceted, multi-sided kind of people. Due to cultural changes, climatic changes, different kind of people we meet in the world. Baba Sahib experienced well all the ups and downs that he faced throughout his lifetime. Our natural laws, fundamentals provide us democratic attitude, holistic attitude for everyone. So let us pay attention towards such things. What is criminal behavior? Throw light on its various theories. The expression criminal behavior is a very familiar term in criminology. In fact, it is closely related to crime and criminology. It would not be wrong to say that criminal behavior gives rise to crime. Criminal behavior is related to the conduct of the individual. Many times when a person's conduct is found to be adverse or bad, then in general it is said that the conduct or behavior of that person is criminal. Criminal behavior is a very popular word in the world of crime. Despite this, it is difficult to give its universal definition. The main reason for this is that till date, the universal causes of crime have not been ascertained. In almost every period, different reasons have been given by thinkers and different acts for crimes. For this reason, Sutherland had to say that just as germs cannot explain all diseases, similarly it is also possible that no one theory of criminal behavior, that is conduct, can explain all criminal behaviors. The principles should be defined in such a way that all the principles can be denoted and together all the principles can explain the entire criminal behavior. Sutherland principles of criminology describe this. Sutherland has given the definition of criminal behavior according to him. Criminal behavior is behavior that violates a criminal law, an act, however, reprehensible, immoral, or improper, is not considered a crime unless it is prohibited by a criminal law. It becomes clear from this definition that any behavior can be called criminal behavior only when it is prohibited by any criminal or penal law. Any behavior or conduct may be morally inappropriate, may also be reprehensible, but if it is not prohibited by the law, then it will not be called criminal behavior. Thus the main criterion of criminal behavior is behavior or conduct prohibited by law. We can explain this by an example. A and B are two persons swimming in a river. Meanwhile, B starts drowning in the river. A is watching but does not try to save him. This behavior or conduct of A may be morally or temporarily improper, but it cannot be called criminal behavior because A is not doing any behavior which is prohibited by law. But in the same case, if A intentionally drowns B in the river, then his behavior or conduct will be considered as criminal behavior because this act of A is prohibited by law. Taft is also of the same opinion that criminology in true sense is concerned only with such acts which are punishable under criminal or penal law. This also makes it clear that criminal conduct means only such conduct or behavior which is prohibited by the criminal law. Criminology does not Criminology deals only with such acts which are punishable by law. Only those acts which are prohibited or punishable by law are mentioned in criminology. It does not mention such acts which are not punishable, prohibited by law. These definitions give an impression of two types of behavior or conduct. One is lawful conduct and two is unlawful conduct. In fact, illegal conduct is criminal behavior. What are the components of criminal behavior? The components of criminal behavior refers to the process of everyday life that lead to such behavior. It is through such processes that criminal behavior is nurtured in humans. Such components of criminal behavior are: criminal behavior is a continuous process. For example, once criminal behavior is generated in a person, it becomes an integral part of life. If it continues continuously, a person with mature criminal behavior or conduct accepts punishment as a philosophy of life. When the person with criminal behavior or conduct are separated from the general public or society, then they become a separate group of their own and their activities are kept secret by such group. There is always a struggle going on between persons with criminal behavior or conduct, those with non-criminal conduct. People with criminal behavior are always looked down upon, and there is always a conflict between such people. There is always a competition going on between the persons who commit crimes and the agencies which deal with them. Criminals always find new ways to commit crime. When crime prevention or investigation agency gives rise to new techniques and technologies to reach the criminal from crime, to facilitate the commission of crime, the accused form criminal organization and commit crime in a systematic manner by planning. Some criminals accept crime as a profession. Such criminals are skilled and efficient. Gradually, such criminals develop a code of conduct, and they are bound to follow the code of conduct. What are the principles of criminal behavior? There are various theories of origin of criminal behavior. The following are the main of these principles. Lombroso's theory. What is Lombroso's theory? Lombroso was a noted criminologist. According to him, criminals are God. That is, criminals are criminals by birth. It is difficult to reform such persons. But now, this theory has almost become dead. It is now well established that a person is not born a criminal. In fact, the circumstances make him a criminal. This has been explained in detail in the previous chapters. What is Tade's theory? Tade believes that criminal tendency in a person is not hereditary. In fact, crimes are learned over time. Tade has propounded the principle of imitation in this regard. According to him, as the population increases, the tendency to imitate crimes increases. In other words, it can be said that, according to this theory, crime is a learned profession. Criminals are not made, but are made. Just as a person becomes a businessman by learning a business, in the same way, a person becomes a criminal by learning a crime. Sutherland's theory says the principle of differential association has been propounded by Sutherland. According to this theory also, criminal behavior is not inherited but learned. It comes from interaction through the process of communication. A person becomes a criminal by being in the company of other criminal persons. Social disorganization is also the basis of his theory. In his opinion, crime and social disorder arise only because of the beliefs accepted by the society. Alice says that people who are unable to adjust themselves in the society due to these social values, they tend towards criminality due to lack of mental balance. This act of his anti-social, in his opinion. Emotional imbalance is the main reason for crime. In the opinion of Professor W.A. Bonner, the poverty prevailing in the capitalist economy is the main cause of crime. Robert K. Merton, while establishing the relation of social structure and culture with criminality, had shared that due to the ever-changing environment of the society, its prevalent beliefs are adversely affected. And when social and cultural values decline, criminality is promoted. Donald theft also continued to grow in America. Transgression is said to be the result of degradation of general cultural values. Donald theft ideology, influence of social values and culture. The cultural nature of society affects criminality. There are the reasons for this due to social and cultural disparities of wealth and poverty prevailing in the society. Sometimes poor and low-class people commit crimes to fulfill their needs or to hide their shortcomings. Crimes like prostitution, adultery, gambling, etc. are good examples of this. The standards established by the class considered enlightened and prestigious in the society, or their activities have an indirect effect on the weaker class. When this class earned money from acts like bribery, corruption, white-collar crime, tax evasion, then the lower class of the society also turns towards such crimes. Increasing criminalization in politics also affects the weaker section of the society. When politicians and public representatives commit crimes without any hesitation, it is not surprising that this vulnerable section follows them. Class struggle, harassment of working women, by employers. Cohabitation of men and women, etc., have also led to increase in criminality. Thus, it is clear that there are many elements and components that influence criminal behavior. What is the main contribution of Lombroso to criminology? Let us explain and illustrate this theory of criminology. What is Lombroso regarded as father of? Why is Lombroso regarded as father of modern criminology? In Lombroso theory of criminology relevant in the present perspective. Lombroso occupies an important place in criminology. He is considered as the father of positive school of criminology. Lombroso was an Italian and served as a doctor in the Italian army and a professor of medical science in Turin University. Lombroso, while adopting objective and empirical system, tried to trace causes of crime in the body and mind of the man. He studied many patients and concluded that the physical condition, the physical constitution of people committing crime is of very low level. He has also tried to prove that the people committing crime have greater capacity to tolerate pain and torture as compared to that in normal person, and therefore they did not get frightened from punishment. Lombroso said that for detecting the criminal instincts in a man, his personality should be studied. This school of thought is known as Italian school of thought. What are the types of criminals? Lombroso has mentioned three types of criminals. Born criminals or atavists, insane criminals and criminals. What are the types of criminals? Criminals. Lombroso has mentioned three types of criminals. One is born criminals, two is ancient criminals, and three is criminals. What are born criminals? Lombroso was of the view that there are some persons who are born criminals, that are the criminality is hereditary in them. It is very difficult to check or prevent criminality in them because they are not affected by circumstances. It is impossible to change them. Lombroso, while analyzing their physical features, has shared that these people normally are sufferers of an epilepsy. They are self-praising and of ostentatiousness, ostentatious nature. Their conduct and behavior is indecent and terrible. Some irremovable spots are found on their body. characteristics of hereditary or born criminals are their circle is round like a flower. Jaw is long and large with towards below or suppressed inside. Nose is flat and wide. Ears are long and thick. Brain is triangle of the shape of a bull. Undeveloped teeth. Thick and black hair. Lips having cuts and the body is without hair or with excessive hair. What are ancient criminals according to Lombroso? The second type of criminals are those who are insane. They have no mental capacity to distinguish between right and wrong and to understand the consequences of the acts. This is the reason that they are not much sensitive to crimes. What are criminaloids? In this category, such persons are placed which have defective physical constitution. The physical constitution has been mentioned here. Because of such physical constitution, they suffer from inferiority above, they suffer from inferiority complex and induced towards crime. While mentioning the cause of crime, Lombroso has said that in this respect it is desire to think over biological nature of human behavior, torture and punishment. Lombroso was of the view that punishment is very necessary for the safety of society and prevention of crime. He was supporter of death punishment in case of serious crimes. The first objective of punishment should be the security of society, and the second is the reformation of criminal. The punishment should be given taking into account the physical and mental conditions. Punishment should not be given to minor and insane criminals. They should be reformed. Lombroso has also said that the sufferers of crime should be compensated by the criminals. What is the contribution of Lombroso? Though the theory of Lombroso was criticized by some criminologists, despite this, his contribution to criminology cannot be forgotten. To say that Lombroso is father of modern criminology and his views are consistent and relevant today because Lombroso was the first person who studied in depth about criminals nearly in the year 1870. He refused the false principle of pre-classical school that man does not commit crime only under compulsion by some devilish powers, that is, power of ghosts, Satan, devils, and giants. Lombroso tried to search causes of crime in the man himself and pointed out the physical constitution and mental condition as the symptom of crime. Lombroso had laid greater emphasis on criminals rather than on crime and accepted their importance. He studied many criminals in insane houses and persons and detected criminal insane on the basis of physical constitution as a physician. He was of the view that punishment should be given according to physical and mental condition of criminals. The minor and insane person should not be punished, they should be reformed. He developed the theory that the first objective of punishment should be social security and the second should be reformation of the criminal, thus considered punishment as necessary for social security. He advocated death punishment in case of serious crimes. Donald R. Taft said that the effect of Lombroso on criminology and penal policy is indicator or proof of his importance. He started use of numerical numbers in analyzing the physical constitution of human. Despite such contribution of Lombroso in criminology, he accepted in the last few years of his life that his concept of hereditary criminal was far from reality. He adopted positive and objective view thereof right later on. These ideas have contributed in development of multi-factor school. Let us discuss briefly the Sutherland important contribution to criminology. What do you know about Sutherland's contribution to the modern criminology? Sutherland's contribution to criminology is significant. The name of Sutherland in criminology is considered as very important. He is considered as father of sociological school of criminology. His contribution in the development of criminology is beyond comparison. Sutherland's sociological school of criminology. The sociological school of criminology is the most developed theory of modern age. Sutherland is considered as the father and strong supporter of this theory. Sutherland defines criminology as a branch of knowledge which treats crime as a social event. There are three types of procedures that are included in this social event: law making procedure, procedure for violation of law, social reaction as a result of violation. Let us take break, please. The name of Sutherland in criminology is considered as very important. He is considered as father of sociological school of criminology. His contribution in the development of criminology is beyond comparison. Sutherland Sociological School of Criminology. The sociological school of criminology is the most developed theory of modern age. Sutherland is considered as the father and strong supporter of this theory. Sutherland defines criminology as a branch of knowledge which treats crime as a social event. There are three types of procedures are included in this social event. One is law-making procedure. Under the first procedure, scientific analysis is made of those circumstances under which criminal law is enacted and its development takes place. This is known as sociology of law. Under the second procedure, all procedures of violation of law are included. Despite the prohibition of crime, a group of society violates criminal law. Criminology discusses and analyzes all these causes on scientific basis, which are at the root of criminal conduct. This is known as the positive theory of crime. Under the third procedure, the reaction is made by the individual, society, and the state on commitment of crime. This procedure is expressed by way of penal action. The branch of knowledge of criminology which analyzes this reaction is known as penology. Sutherland is of the view that criminology conduct arises from those procedures from which other social conducts arise. The analysis of these procedures related to criminality have taken mainly in two forms. Firstly, the sociologists have tried to link the difference in rates of commitment of crime with old institutional methods with change in social organization in societies or sub-societies in respect of change of rates of commitment of crimes. Some social conditions have been described, some of which are procedure of mobility, cultural contradictions, competition, standardization, religious, political, and economic ideology, density of population and organization, and distribution of wealth, income, and planning. Secondly, the sociologists have tried to analyze those conditions under which a man becomes criminal. These analyses were related with the normal principle of adoption, tendency, values, distinguishing, association, and to some extent the effect of despair and compensation. From the above analysis, it is clear the crime is aberrant behavior. He said that the crimes are not invented, but they are learned. A man who accomplishes the type of people, he does the same type of work. A person conducts in the same way as the other does in association with him. Sutherland's theory in respect of criminal conduct. The theory which was developed by Sutherland for analysis of criminal conduct is known as theory of differential association. In reality, this is historical interpretation of criminal conduct. The following are the assumptions of this theory. The criminal conduct is the result of learning. It cannot be hereditary. A criminal conduct is learned in association with other person by way of action-reaction. The main part of learning of criminal conduct takes place among well-known groups of persons. Many things are included in the learning of criminal conduct: technique of conduct of crime, motives, wishes and attitudes, and special directions therefore. Special direction for motives and attitudes is learned from the favorable and unfavorable definition from legal courts. A man becomes criminal when the definition of violation of law is more favorable or beneficial for him as compared to the definition of violation of law, which is unfavorable. This is the theory of different association. A person becomes criminal in association with criminals, criminal tendencies, and separation from non-criminal tendencies. Differential association, continuity, time period, priority, and fitness, they can be separated from each other. If a man, for example, if a man comes into contact continuously with criminal conduct, they may become criminal. Similar, if a person comes into contact with non-criminal association continuously, he may develop non-criminal conduct. The conduct which remains persistent for a longer period remains effective and affects men. In association of criminal and non-criminal conduct, the same instincts remain present in learning of criminal conduct, which remain in learning of other things. Though criminal conducts are expression of normal needs and values, but they cannot be interpreted by normal needs and values because non-criminal conducts are also the expression of same needs and values. Thus, by development of criminological theory, Sutherland has given new direction to the positive theory of crime. What are the criticism of it? Sutherland's theory is criticized by saying that the differential association is not important in itself. Individuality takes shape of that opportunity in which personal traits are expressed which are embodied in personality. The theory of the theory does not explain this fact that a person who remains in particular association or atmosphere forms his conduct as criminal, while the other person remaining in the same atmosphere does not. There are many criminal conducts which are formed suddenly and they have no concern with learning. According to George Wald, if crimes are analyzed with the theory of differential association, then it goes far off from the boundary of reality because it is difficult to think of crime in association with any power. Crime in reality is a byproduct of many causes. The only common thing is the violation of criminal law. Despite all this, Sutherland has given new direction to criminology and tried to make it objective and scientific. Let us discuss the contribution of Enrico Ferri and Raphael Fellow in the development of technology, Enrico Ferri. Enrico Ferri is considered to be an important contribution in the development of technology. Enrico Ferri was a disciple of Lombrosher and he carried forward the ideology of Lombrosher. Enrico Ferri propounded the theory of criminal saturation. Ferri was of the opinion that sensitivity, social inefficiency, geographical location, etc., also have an important hand in the factors which motivate the person towards crime. Ferri has also held social conditions responsible for crimes. Enrico Ferri considers crime as a combined result of physical and mental characteristics and social conditions. Ferri believed that just as a certain volume of water at a certain temperature would dissolve a certain amount of chemical substance, so a certain number of crimes would be committed in a certain social environment with certain personal and physical conditions. Enrico Ferri has classified crimes into the following five thoughts. One is born criminals, who is occasional criminals, who is passionate criminals, for his insane criminals, and five is habitual criminals. Ferri was of the firm belief that crime was a necessary evil. As long as there is society, there will be crimes. If the criminals should be punished, then at the same time they should also be treated. Ferri was against capital punishment and retributive punishment. Ferri's important contribution towards the end of his life was the initiation of the crime prevention campaign for the prevention of crimes. Ferri has mainly given three reasons for crimes: physical or physiological cause, psychological or anthropological reasons, and social causes. Ferri was of the opinion that it is not fair to hold the offender responsible for his criminal acts because he commits the offense due to the combined effect of circumstances. Therefore, efforts should be made to eliminate the causes of crimes by finding them. As shared above, Enrico Ferri was the exponent of the theory of criminal saturation. According to this theory, a number of factors combine to create a situation that is conducive to criminal conduct. But the shared theory of Ferri is criticized by the critics by saying that it is only a special form of law of cause and effect applied to criminal conduct. Overall, Enrico Ferri is considered the originator of criminal sociology. He is also called a strong supporter of the positive school. Raphael Garofalo. Raphael Garofalo was also a disciple of Lombroso and a contemporary of Enrico Ferri. Garofalo was born in 1852 in the city of Naples, Italy. Garofalo's personality was multifaceted. He had been a senator, professor, and magistrate. This is the reason that Garofalo had a wide knowledge of criminal law, criminal procedure, and the problems related to them. Most of his time was spent in thinking to solve these problems. Garofalo did not agree with the hedonistic philosophy of crime, and the theory of free will, giving a new definition of crime. He said, crime is such an act committed by a person due to which the feelings of mercy and justice inherent in a normal person are attacked and which it is harmful for the society. It is clear from this definition that when a person lacks the feeling of kindness, then he commits crimes related to body, and when there is lack of justice, that is truthfulness, then he commits property related crimes. Fellow classified crimes into four categories. One is murderers or endemic criminals, two is violent criminals, three is criminals lacking sentiments of probity, and four is lustful criminals. Fallow's views on punishment were based on his long experience. He believed that in crimes of serious nature, capital punishment can also be given to separate the criminal from the society. The punishment of long-term imprisonment, life imprisonment, or exile can be given to habitual offenders who are dangerous to the society. In offences of ordinary nature, instead of the punishment of imprisonment, fine can be given. Such amount can either be deposited in the treasury or can be given as compensation to the aggrieved party. Thus, Garofalo was a supporter of the following four types of punishments: the death penalty, imprisonment for life, deportation, and fine. Garofalo was not optimistic about the remedial punishment system, so he did not insist on this system. Let us discuss the Gabriel Pratt's contribution in the development of criminology. Gabriel Tarde is considered to be one of the strongest critics of formalist ideology. He was of the opinion that the following two things are mainly responsible for criminal conduct: social conditions and the surrounding environment. Biological and physical elements have little effect on criminal conduct. On the basis of his long experience, he tried to prove that the basic basis of crimes is humans, insertion and natural nature of imitation. Human beings have a strong tendency to illuminate their peers or associates. Younger people always desire to emulate other people. This is the reason that when new criminals come in contact with habitual criminals in the criminal world, they start imitating them. Adolescents are more inclined to emulate adults or adults. By imitating them, they try to play the role of the hero or villain of TV, cinema, or drama. They start adopting gestures, activities, behavior, fashion, etc. according to them. As we know, children have less power to think and understand, or they are in immature state. So they start doing wrong, faulty or illegal actions in a hurry, and their interest towards such actions also increases. Thus it is clear that Gabriel Tarde considers imitation as the main reason for criminal behavior, and it is because of imitation that people tend to commit crimes. Gabriel Tarde has classified criminals into two categories. One is urban criminals and two is rural criminals. After a deep study, he found that the urban criminals are more clever and dangerous than the rural criminals. This is the reason why crimes committed in urban areas are more serious than those committed in rural areas. In this way, Gabriel Tarde, while rendering the theory of imitation in criminology, has shared that crime is a learned business. As the population increases, the number of crimes also increases. More crimes are committed in cities than in villages. It has been the belief of Tarde that due to criminal tendency being a learned profession, the cities where there is more efficiency, mobility and training facility, crime are committed in relatively higher quantities. If we observe Tarde's theory of imitation in the Indian context, here it is more prevalent. Due to the political anarchy and criminality here, most of the people follow the politicians. Imitating the criminal tendencies of politicians, people start adopting the path of violence, exploitation, corruption, bribery, looting, terrorism, etc. Today's corrupt and criminal political environment is a vivid example of this. When a politician commits a crime, his followers also follow him. Thus, Gabriel Tarde's theory of imitation was relatively more practical and rational, but he could not get much recognition in criminology because it was very simple in practice. Nevertheless, this principle is considered to be an important contribution in the prevention of crimes. The French criminologist Gabriel Tarde is considered a strong proponent of ecological thought. The essence of his principle of imitation is crime is a learned profession. Crime also increased with the increase of population. Concentration of population increases the amount of imitation, and cities where skill and training are more, crimes are more committed in those cities. Let us explain the Beccaриa's contribution in criminology. Beccaria was a noted criminologist from Italy. He started the real systematic study of criminology. This is the reason why he is called the father of criminology. In fact, Beccaria was the first person who systematically studied criminology in a scientific manner and propounded certain principles. As a result of this, policies regarding behavior towards criminals and a plan to establish control over crimes were prepared. Beccaria is considered the father of classical thought. He has presented his principles in a book called Crime and Punishment, refuting the principles of demonic ideology. They initiated the theory of free will of man related to criminology. The whole theory of Descartes has been explained by Donald the Taft in this way. Each person has his own concept of happiness and sorrow, and it is a natural tendency of a man to make maximum use of happiness and avoid sorrows. Because of this desire for happiness, he sometimes commits crime. In other words, it can be said that whatever a person does, he does with his free will. In every walk, he thinks about his benefit or harm, or happiness or sorrow. Whatever work he finds good and pleasant for himself, he does that work. Crime is also the result of this. If he gets pleasure from a criminal act, then he does that act, even if it is a crime. Thus, the root of the theory of the free will is hedonistic philosophy. Descartes, in his theory of free will, had considered man's own free will as the root cause of crime. He had fully explained in his theory in this book, Crime and Punishment. According to him, crime is based on hedonistic philosophy. A person commits a crime only when he gets more pleasure than pain in it. Happiness and unhappiness are determined on the basis of human conduct, and there is a difference in the nature of man and man. Man's behavior is the result of his own responsibility. Descartes has given three types of crimes: offenses against the state, such as sedition, treason, military mutiny, etc. Crimes against body and property, such as murder, assault, theft, rape, kidnapping, theft, robbery, dacoity, etc. Offenses disturbing social peace, such as riot, commotion, mutiny, etc. In this way, Descartes first initiated the systematic and rational study of criminology, which was later recognized as a scientific approach. His most important contribution to criminology is the development of an independent branch of knowledge. In it, in its criticism, we can say, despite all this, Beccaриa's theory has been criticized by the critics. The free will of the criminal has been given unnecessary importance by Beccaria in his theory of free will. The theory of free will ignores the mental state of the criminal. In this theory, our distinction has been made between crimes of simple and serious nature. The provision of punishment made in it is not reasonable in the present context. Apart from free will and hedonistic philosophy, there are many other causes of crime which have not been taken care of in Beccaриa's theory. Let us discuss the theory of utilitarianism of Bentham. Let us explain the contribution of Bentham in criminology. Bentham's important contribution. Listeners, let us take break, please. Let us discuss the theory of utilitarianism of Bentham. Explain the contribution of Bentham in criminology. Bentham's important contribution is considered in the field of legislation and criminology. Bentham is the first person who, on the basis of his theory of utility, Bentham's important contribution is considered in the field of legislation and criminology. Bentham is the first person who, on the basis of his theory of utility, had prepared various plans to remove the evils prevalent in different areas of public life. Bentham propounded the utilitarian principle and indicated that laws should be made keeping in mind the principle of utility. Bentham's famous work is The Principle of Morals and Legislation. What is utilitarian theory? Bentham's utilitarian theory is a theory based on utility. According to Bentham, utilitarian principle refers to the principle by which the happiness of the concerned person increases or decreases, and on the basis of which he justifies on the basis of which he is justifies or unjustifies every action. Bentham's utilitarian theory is based on the concept of happiness and unhappiness. Bentham says that placed man nature has placed man under two sovereign masters, pleasure and pain. It is their duty to tell us what we should do and decide what we can do in future. Bentham also says that the main objective of the legislator should be to encourage happiness and prevent unhappiness. Thus, the main basis of Bentham's utilitarian theory is the concept of happiness and unhappiness. According to him, the only measure of utility of a thing is the extent to which it increases or decreases happiness. It is happiness and sorrow that give impetus to human life. Utility of utilitarian principle in lawmaking. Bentham is considered the father of utilitarian theory. He had presented the utilitarian principle very beautifully. Bentham says that the legislator should keep in mind the principle of utility while making laws. In this context, Bentham presented another principle. Maxims, maximum happiness of maximum people. This means that The aim of the state should be maximum happiness of maximum people. In this way, Bentham's utilitarian theory gives more importance to the interest of the common man by rising above the individual. The methods should be such that they bring maximum happiness to the maximum number of persons. What is the contribution to criminology? Bentham's utilitarian theory also had an important contribution in criminology. Bentham believes that the person does only that work in which he gets pleasure, even if it is a crime. According to Bentham, happiness and unhappiness are the product of the mind. The person who gets pleasure in the work, that is happiness for him, and the work in which he gets sorrow is sorrow for him. Bentham has given 14 types of happiness and 12 types of sorrow. If a person finds pleasure in torturing others, then that is pleasure for him. Even if it is a crime, this is called the pleasure of misery. Thus, utilitarian principle has given has been applied in criminology as well in its criticism. Bentham's utilitarian theory has been criticized by the critics on the following grounds. Bentham's utilitarian theory gives more importance to physical pleasures while neglecting morality, which is not appropriate. Bentham gives importance to happiness in life, not to sacrifice and abstinence. Bentham has given more importance to personal happiness. His ideology is individualistic. The concept of maximum happiness of maximum number of persons is not practical. Bentham's utilitarian principle gives more importance to the quality while neglecting the quality which is not appropriate. Let's explain the socialistic school of criminology. Let us discuss critically the Bonger's economic theory of criminality. The socialist ideology of criminology is mainly based on economic determinism. The promoters of this ideology are Marx, Engels, and Bonger. According to them, economic conditions have a deep relation with crime. There are the main economic conditions which have a direct relation with crime. Direct economic purpose. One is direct economic purpose. Two is poverty. Three is anger against economic exploitation. Four is the impact of commercialized entertainment. Five is unemployment. Six is behavior patterns. And next is economic basis of social prestige. For example, Marx and Engels. Marx and Engels propounded the theory of economic determinism and said that the entire history is based on the economy. Marx propounded the theory of surplus value. According to him, due to the surplus value, the society gets divided into different classes, resulting in class struggle. According to Marx and Engels, production is motivated by economic interest, and economic interest gives rise to class struggle, which has a direct relation with crimes. The rate of crimes depends on the economic conditions. Difference in crime rates is found due to difference in economic conditions. Crimes are more when the economic conditions are unfavorable and less when they are favorable. Bonger was a famous Dutch criminologist. He is considered a strong supporter of socialist ideology. According to him, the root cause of crime is the spirit of selfishness. A person commits crime only because of selfish tendency. Crime is directly related to the economic system, as in capitalism. Production is not for consumption but for earning profit. The tendency to earn more and more economic benefits gives rise to competition, and competition leads to disintegration in the society and increase in the number of crimes. Competition, irrespective of classes, results in crime. Competition gives birth to child labor and women labor, and these lead to conflicts and increase in crimes. The main causes and factors of crime are as follows. One is vagrancy from unemployment, two is theft due to economic disparity, three is crime due to envy of the wealth of rich people, drinking and prostitution due to lack of healthy entertainment, sexual offenses, etc., due to economic poverty, not getting married in time. All the crimes committed by habitual criminals arise out of economic reasons only, due to the desire to get rich without work and labor. What is first information report? Let us explain its contents. What is the effect of its late filing? First information report is the first stage of investigation. In fact, the investigation starts from the first information report itself. It is also called FIR or first information in short. Section 154 and 155 of the Code of Criminal Procedure 1973 have made provision regarding first information report. Section 154 deals with cognizable offences and Section 155 with non-cognizable offences. In its definition, the term first information report has not been defined in the Code of Criminal Procedure 1973. It has been defined in various judicial decisions. In the case of Sonlal versus State of Punjab AIR 2003 AC 4466, it has been defined as follows. First information report is not substantial evidence. It is merely an intimation. It is merely an intimation of the commission of an offence. In the case of State of Uttar Pradesh versus Munish, AR 2013 SC 147, it has been said by the Supreme Court that the first information report is just the information about the incident. It is not necessary to give all the details of the incident. Thus, it becomes clear that first information report is a notice of commission of an offence. How is it given? The first information report can be given in any form, written or oral. If such notice is given orally, it shall be recorded in the relevant register. It shall be read over the person giving the information. It shall be signed by the person giving the information, and a copy thereof shall be given free of cost to the person giving the information. Subsection 1 and 2 of Section 154 of the Part of Criminal Procedure 1973. First information report can also be lodged over telephone. Sunil Kumar versus State of Madhya Pradesh, area 1997, SC 19940. But she create or coded information given over telephone shall not be treated as first information report. Surjit Sarkar versus State of West Bengal, area 2013, SC 807. Who can file first information report? Generally, the first information report is lodged by the aggrieved person himself. This is not always necessary. Any relative, friend, or person familiar with the incident of the aggrieved third party can also file a first information report. In the case of Murugan versus State AIR 2009 SC 72, it has been held by the Supreme Court that where the injured person had sustained grievous injuries and is in an unconscious state, the police official may get such a report written by an eyewitness to whom it will be given. Normally, the first information report is given to the officer in charge of the police station, section 154(1), but it has been held by the Supreme Court in R.C. Kapoor versus Sarkar Pratap Singh Caro, AIR 1961, SC 1717, that it is not necessary that the FIR should be made only to the officer in charge of the police station. It was meant that the first information report can be given to any officer of the police station. What are the duties of police officer? As soon as such first information report is received, it is statutory duty of a police officer to enter in the relevant register without delay and do not cause unnecessary delay in registering the same. Unnecessary delay leaves the case of the prosecution doubtful. Ganesh Bhavan Patel versus the State of Maharashtra, AIR 1979, SC 135. It has been held by the Supreme Court in the case of the State of Haryana versus Chaudhary Mijanlal, AIR 1992, SC 604, that if the first information report reveals the commission of a cognizable offence, the official in charge of the police station shall register such report. Apart from this, there is no other option left before him. In the case of Ramesh Kumari versus State AR 2006 SC 1322, it had also been held by Supreme Court that the provisions of Section 154 are mandatory whenever an information report disclosing a cognizable offence is presented to the officer in charge of the police station. He is duty bound to register it. It has been held by the Supreme Court in State of Madhya Pradesh versus P. Ramulu, AIR 1993, SC 2644, that the officer in charge should not refuse to lodge a report merely on the ground that the offence was not committed in his local jurisdiction. In such cases, it is his duty to write the report and send it to the concerned police station. If the first information report is not registered by the officer in charge of the police station, such information may be sent by post to the Superintendent of Police. Section 154C of the Code of Criminal Procedure to be recorded by the lady officials. In the proviso to Section 154 it is stated that the report of cases related to rape shall be recorded by a woman police officer or other woman officer, and if the woman victim of rape is physically or mentally handicapped, such report shall be made by such woman at the place of residence or at any other convenient place, shall be recorded in the presence of an interpreter or counselor, and his video film will be prepared. Contents of the first information report, as held in the case of Sondal versus the State of Punjab AIR 2003 SC 4466. First information report is not a material evidence. This is only information about the incident. A similar view has been expressed in State of Uttar Pradesh versus Munish AIR 2013 SC 147. It has been said in this that first information report is only information about the incident. It is not necessary to give all the details of the incident. The intention is clear that only essential things, facts should be mentioned in the first information report. In the case of Motilal versus the State of Uttar Pradesh AIR 2010 SC 281, it has been said by the Supreme Court that it is not necessary to give every minute detail of the incident in the first information report. In the case of State of Uttar Pradesh versus Ballabh Das, AIR 1985 SC 1384, it has been laid down by the Supreme Court that first information report is not a detailed document. Only the essence of the event is mentioned in it. Therefore, if the lathi is not mentioned in the first information report, then the case of prosecution will not be considered doubtful merely on this basis. In this case, in the case of Gurnam Kaur versus Bakshish Singh, AR 1981 SC 631, it has been said by the Supreme Court that where a first information report is filed by an unprivileged ordinary rural woman only on the basis of it will not be considered invalid if certain facts related to the incident, such as blood stained clothes, etc., have not been mentioned in it. In the case of State of Rajasthan versus Annie alias Hani Payar 1997 SC 10/23, the omission of the names of eyewitnesses in the first information report was not considered serious. It was a case of murder. In the case of Sahib Singh versus the State of Rajasthan, AIR 1997 SC 1945, the first information report omitted to name the wife of the deceased as an accomplice. It was not considered fatal. In the case of Kishan Chandra Mangal versus the State of Rajasthan, AIR 1982 SC 1511, it was not absolutely considered necessary to name the accused in the first information report. If the accused is a government servant, it is sufficient to mention it first or first. In the case of Ashok Ram versus the State of Odisha, AR 2016 SC 589, the Supreme Court held that where the eyewitnesses have seen the accused with deadly weapons at the place of occurrence and the medical evidence corroborates the yes, there is no fatality in not mentioning the names of the accused in the first information report. The case of latest versus the State of Maharashtra, AIR 2018 SC 659. It has been held by the Supreme Court that the mere absence of the name of the accused in the first information report does not lead to the disbelief of its content. Overall, it can be said that the first information report is merely a notice of the occurrence, that is, of the commission of the offence. It is not necessary to give particulars of all matters therein. Mention of only essential things and facts is considered sufficient. What are the effects of delay? Delay in justice is injustice. First information report is expected to be lodged immediately after the incident or without unnecessary delay. Due to unnecessary delay, the matter starts to look suspicious. But this is not an absolute rule. If there is delay in filing the first information report, then it is excusable. The only requirement is that there must be sufficient reason for the delay. In the case of Parminder Kaur versus State of Punjab AIR 2020 SC 815, it has been laid down by the Supreme Court that the delay in lodging the first information report depends upon the circumstances of each case and the behavior of the parties. In the case of Ram Kumar versus the State of Haryana AIR 1995 SC 280, the incident took place in the evening and the first information report was lodged the next morning. It was not considered to be filed with unnecessary delay because the incident took place on one side of the village. The complainant was a widow. He himself, his one minor child, and two other persons were injured in the incident. There was no other male member in the family, and the complainant was scared and took shelter at her neighbor's place. In the case of Murari Thakur versus the State of Bihar, AIR 2007 SC 1129, there was some delay in filing the first information report because the father of the victim had gone out and returned home late at night, and the investigating official could not reach the spot immediately due to flood. This delay was not considered fatal. In Tamil Alliance Tayal versus the State of West Bengal AIR 2008 SC, where the police station was a little far from the village. It was raining heavily at the time of the incident, due to which there was a slight delay in informing the police station. This was considered an adequate and reasonable explanation for the delay. In the case of Kanhaiyalal versus the State of Rajasthan AIR 2013 SC 1940, it has been propounded by the Supreme Court that delay in lodging first information report is not always fatal. It depends on the explanation of the delay. In the case of Kailash Gaur State of Rajasthan AIR 2012 SC 786, it has been said by the Supreme Court that if the delay in filing the first information report is not explained, the accused is entitled to benefit of doubt, becomes entitled. In the case of Krishnan versus State AIR 2003, SC 2978, it has been held by the Supreme Court that lodging of first information report immediately after the incident gives rise to the presumption of false involvement of a person in the incident. Overall, it can be shared in a sense that the first information report should be lodged immediately after the incident or without unnecessary delay. First information report is not material evidence. Let us discuss this statement. Let us throw light on the legal value of the first information report. Let us explain the authenticity and retention of first information report from the point of view of investigation. First information report is very important. In fact, first information report itself is the first and initial stage of investigation. Investigation is started only on the first information report. Despite all this, the factual value of the first information report has been considered very weak. In the case of Sonlal versus State of Punjab area 2003 SC 4466, it has been said by the Supreme Court that first information report is not a material evidence. It is only an information about the commission of an offence. In the case of State of Uttar Pradesh versus Minishu, area 2013 SC 147, it has been also laid down by the Supreme Court that first information report is only information about the incident. It is not necessary to give all the details of the incident. In the case of Mahipalpur Cooperative Society Limited versus Srimati Prabhavati AIR 1986 Delhi 94, it has been held by the Delhi High Court that first information report is not material evidence. The statements contained therein can only be used to refute or prove the witness to be unreliable. It has been held by the Supreme Court in Alagar Swami versus State EIR 2010 SC 849 that the first information report, though an important document, is not the be all and all. It is not a universal rule that a slight contradiction in the first information report renders the entire case of the prosecution unreliable. It has been held by the Supreme Court in Baldev Singh versus State of Punjab EIR 1996 SC 372 and Narayan Mahto versus State of Bihar EIR 1995 SC 1437. The first information report is not a material evidence. Merely on the basis of first information report, the accused cannot be convicted. The facts mentioned in such report need to be proved in the court. In Savi versus State of Tamil Nadu, AIR 1981, SC 1230, it has been held by the Supreme Court that it is the duty of the police officer to maintain the authenticity of the first information report. If he accepts the original report and puts another report in its place, and when the accused makes a complaint to this effect and the diary of the police station related to the report is not produced, even when the court is required to produce it, then it can be inferred that the original first information report has been suppressed. This fact makes the prosecution case suspect. It is clear from the above decisions that first information report is not a weak evidence. It is not material evidence. It can be used only for rebuttal or may be done to discredit the credibility of the witness. This is also confirmed from the following, that is, first information report is not a substantial evidence. This is also confirmed by the following facts. The delay in registering it may be condemned. The omission of any matter or fact there is not considered to be fatal. It does not necessarily give a complete account of the incident. and merely on the basis of this the accused cannot be convicted. In its conclusion we can say, despite all this the importance of first information report cannot be denied. It has its own importance to some extent because it gives information about the event, it bears the name of the accused, it gives information about the time and place of the event, an estimate of the damage caused to the complaint. This keeps the names of the companions marked. It gives impetus to exploration, guides the investigating officer, and it determines the extent, sequence, and nature of investigation. What is investigation? What is the purpose of investigation? Explain the difference between investigation and inquiry. Meaning of exploration. Investigation, also known as research, is an important part of the judicial process in the initial stage. Whenever a first information report about the commission of a cognizable offence is presented by a person to a police officer, the investigation is immediately started by the investigator. According to J. Morgan, investigation is the investigation or communication made to obtain correct information in relation to any accusation. The word investigation has been defined in Section 2H of the Code of Criminal Procedure 1972. According to this, investigation includes all proceedings conducted under this code by a police officer or by any person other than a magistrate has been authorized in this behalf to collect evidence. In this way, investigation includes all those proceedings which by a police officer or by any person other than magistrate who is authorized by the magistrate for the purpose under the Court Criminal Procedure Code and whose object is to collect evidence. Investigation is concerned with a person aggrieved by criminal acts. Witnesses and persons who commit crimes. The investigation begins the moment the police officer meaning of investigation under the Evidence Act. The word investigation as used in section 157 of the Evidence Act 1872 has a wide meaning. In this section, the word investigation means fact-finding process. It is not limited only to the fact that it is done by the police to collect evidence. It has been laid down by the Supreme Court in Union of India versus Prakash v. Hinduja 2003, 6 SCC 195. The investigation is the function of a police officer. He has to ensure the method and process of investigation. The magistrate should not interfere in it as far as possible. In the case of Sudeep Lal Eka versus the state of Odisha, 2014-11 SSC 527, the young teacher had died of burns. The teacher was being sexually assaulted by the accused. An application was submitted for handling over the investigation to the CBI, but the same was refused because the charge sheet was presented against the main accused and the investigation was still open under section 173(8) of the Code of Criminal Procedure. In the case of SN Hagde versus Lokayuk ILR 2004 Karnataka 3892, the Karnataka High Court observed that there is a difference between the investigation as described in the Code of Criminal Procedure and the investigation conducted by the Lokayukta. In the investigation by the Lokayukta, its discretion and the principles of natural justice can be used. In its purpose of investigation, we can say, what's the purpose of investigation? The main purpose of investigation is to collect evidence related to a crime. In the absence of evidence, charges cannot be framed against an accused. Not only this, in the absence of the sufficient evidence, no case can be placed before the court. The investigator has to keep this point in mind at every stage of investigation. In other words, it can be said that the main purpose of investigation is to find out that whether any offense has been committed. If so, what is the offense and by whom is it caused? All this work is done through evidence collection. Here it is worth mentioning that the object of investigation is to go to the bottom of the matter to find out the innocuous truth and not merely to collect such evidence as may lead to the conviction of the accused. Jamuna Chaudhary versus State of Bihar 1974, 3 SSC 174. It is a well-established principle of criminal jurisprudence that prima facie there is a presumption of innocence of the accused. If he is guilty, he must be proved beyond reasonable doubt. No person can be implicated in an offense by the old technique of the investigation. The aim of the investigator should not be that. The aim of the investigator should not be that he should make such a cause and present it before the court so that the accused can be declared guilty by the court. The basic purpose of investigation is to bring out the hidden real truth. Even in Rajasthan police rules, it is the duty of investigating officer to find out the truth of the matter under investigation. Its main objective should be to find out the true facts of the case and arrest the real accused. He should not take an immature view of the facts. He should not take an immature view of the facts against any person. Justice N.K. Senior of the Calcutta High Court had expressed the view in a case that it has never been and cannot be the object of an investigation to try to convict a person in any way. It is his duty to go to the bottom of the matter to find out whether he has actually committed a crime or not. This is necessary for justice. State versus Manindranath Das AIR 1960 Calcutta 183. Finally, it can be said that separating the chaff from the grain, discovering the truth from the falsehood, removing the misleading facts, and finding out the reality from the false and false statements is the main objective of the investigation. Scholarly Investigation Guide, first 5th edition, page number 68. What is the difference between investigation and inquiry? Investigation and inquiry being similar words. Sometimes both are accepted in the same sense, but in fact there is a difference between the two. According to section 2Z of the Code of Criminal Procedure 1973, inquiry means every inquiry other than inquest held under this code by a magistrate or court. Thus, inquiry is mainly done by the court or magistrate, while investigation is done by the police officer or any person authorized by the magistrate. Here are the differences between inquiry and investigation. Inquiry is a preliminary and formative stage, while investigation is a final and decisive stage. In inquiry, both the parties are given full opportunity to cross-examine each other and evidence is taken in the presence of both the parties, whereas in the investigation the presence of both the parties is not necessary at all stages. Inquiry is an introspective process in which the police officer at every stage realizes whether he is on the right track or not, while investigation is an objective process in which the results of the investigation are evaluated and a conclusion is drawn. It had been held by the Supreme Court in Hardeep Singh versus State of Punjab. (2014) 3 SCC 82 that the investigation begins with the presentation of the charge sheet, which has nothing to do with the investigation. It is the function of the magistrate to investigate. What are the different stages of investigation? Let us throw light on the various parts of the investigation in detail. Investigation is an ongoing process. It goes on continuously from the first information report till the presentation of the charge sheet in the court. Meanwhile, it has to go through many processes, such as one is first information report. First information report has an important place in the investigation. It is considered a valuable document. In fact, the first information report itself provides for the investigation. First information report is abbreviated as FIR. In the case of Sonlal versus State of Punjab EIR 2003 SC 4466, it has been said by the Supreme Court that first information report is not material evidence. It is only an information about the commission of an offence. In the case of the state of Uttar Pradesh versus Munish AIR 2013 SC 147, also it has been said by the Supreme Court that first information report is just information about the incident. It is not necessary to give details at the time of occurrence. First information report can also be lodged over telephone. Sunil Kumar versus State of Madhya Pradesh AIR 1997 SC 940. In the case of Surjit Sarkar versus State of West Bengal AIR 2013 SC 807, the Supreme Court held that secret information given on telephone is not a first information report. The first information report may be in writing or oral. There should be no unnecessary delay in filing the first information report. Map of the crime scene. Immediately after receiving the first information report, the investigating officer leaves for the crime scene and inspects it and prepares its map. It is also called map of the spot. The actual position of the spot is marked on the map. This is a valuable evidence. Statements of witnesses. What are the statements of witnesses? Statement of witnesses have an important place in investigation, because only on the basis of statements of witnesses the conclusion cannot be reached whether a crime has been committed or not. It is the duty of the investigating officer to record the statement of the person having knowledge of the incident. Without delay, give priority to eyewitnesses as much as possible. There is no specific rule as to who can be a witness. The child can also be a witness if he has knowledge of the incident. It is worth mentioning here that the witnesses should be provided protection against intimidation, coercion, harassment, etc. There is no specific rule as to who can be witness. The child can also be witness if he has knowledge of the incident. It is worth mentioning here that the witness should be provided protection against intimidation, coercion, harassment, etc. Search and arrest of the accused. When the investigating officer is satisfied, then he takes the step of arresting the accused. It is expected that the accused should be arrested without any delay, as delay increases the likelihood of the accused absconding. But before arrest, it should be seen whether the grounds for arrest exist or not. Remand and bail. Remand has an important place in investigation. It is of two types: remand of police custody and remand of judicial custody. When the investigating officer requires the accused for investigation in the investigation, then remand for police custody is taken. Otherwise, remand for judicial custody. When an accused is in judicial custody, he can be given in police custody for investigation in other cases. As far as bail is concerned, it is the legal right of the accused to be released on the bail on bailable offences, whereas in non-bailable cases, it is the discretion of the court. Search and seizure. Search and seizure is also a part of investigation. There are some rules of search and seizure, such as it should be taken in the presence of two eminent persons. The search of a woman should be taken by a woman is sufficient. As far as possible, not to be searched between sunset to sunrise, etc. Proceedings identification. Proceedings identification means identification of the accused and the property. When the accused is an unknown person, the process of identification is conducted to establish his identity. Similarly, in cases of theft, robbery, dacoity, etc., the process of identification of property is conducted to identify the stolen property. The operation is generally done by the magistrate, but the proceedings for the identification of the accused cannot be conducted in such cases where the inability to identify the accused has been expressed in the first information report itself. Statements of dying declaration. Statements of dying declaration are the statements of persons who are close to death and are given about the causes of death. Such statements are usually murder. In case like Dory death, records are made. Such statements are required to be recorded as far as possible by the magistrate, but in unavoidable circumstances, these can also be recorded by police officials. In the case of Umakant vs. State of Chhattisgarh 2014, 7 SCC 405, the statements of the dying declaration were not considered admissible in evidence because it was not recorded in the court before the accused, and there was also no cross-examination thereon. In the case of Raju De versus the State of Maharashtra AIR 2016 SC 3209, the conviction of overdose based on the statements of the dying declaration recorded by the executive magistrate in the presence of medical personnel was considered appropriate. Medical test, etc. Along with all these, the following also have an important place in investigation: medical examination of the accused and the injured person. One is medical examination of the accused and the injured person. 2 is chemical test. 3 is handwriting and fingerprint test, etc. Generally, in cases of assault, murder, rape, kidnapping, poisoning, etc., medical examination of the injured person is done. Sometimes medical examination is also done to determine the age. In case of rape, medical examination of the both Medical examination of both the accused and the accuser has been considered necessary. As far as the examination of handwriting, etc. is concerned, although it is considered to be weak and unreliable evidence, but sometimes it helps to reach the right conclusions. Where there is a contradiction in the opinion of two handwriting experts on any point, the opinion of such an expert is important, which is based on reasonable reasons. Confession. Confession is also a part of investigation. In section 164 of the Code of Criminal Procedure 1973, provision has been made regarding confession. The accused can be convicted on the basis of confession also. It has been held by the Supreme Court in Jamiluddin Nashir vs. State of West Bengal 2014 7 SCC 443 that if the requirements described in section 164 have been fulfilled in recording the statement of the confessor, such confession shall be admissible in evidence. In its report of investigation, when the investigation is completed, the report of the investigation is submitted by the investigating officer. It can be of two types, in the form of charge sheet or in the form of final report. When the investigation finds prima facie case against the accused, then charge sheet is submitted, otherwise final report. Normally it is recommended not to take the opinion of the public prosecutor before submitting the report. The effect of awareness discovery. Investigation is the cornerstone of the whole case. The success or failure of the case depends on this. Therefore, it is necessary for the investigation to be correct, complete and error-free. But if a defect remains in the investigation, the more defect does not entitle the accused to acquittal, especially when the case against all or some of the accused is found to be clearly made out. State of Uttar Pradesh versus Hari Mohan 2008 SCC 598. Some important things regarding investigation. The importance of research is clear from the above discussion. This is a powerful medium to take the crime to the criminal. Normally, even the Supreme Court does not interfere in the investigation. Therefore, the police official also have a special responsibility towards the investigation. The investigating officer should not cause unnecessary delay in recording the first information report. But if there is delay in the writing the first information report in cases like rape due to the interference of the village panchayat, fear of respect and social prestige, then neither the investigation officer nor the victim will be considered guilty of it. The matter belongs to the jurisdiction of any other police station, then the complainant or the person giving the first information report should not be sent from there for the same reason. But the information should be registered and sent to the appropriate police station. It is noteworthy that in matters of investigation, the police officers should maintain their reputation and credibility. If credibility is lost, the case can be handed over to CBI or any other agency for investigation. Let us throw light on the process of investigation in the cases of murder and culpable homicide. Among the crimes committed against the body, this is a crime of serious nature. In this, the death of another human being is caused by one human being. There is a variation of this. There is 13. Difference between culpable homicide, that is murder, and culpable homicide. All murders are culpable homicide, but not all criminal homicide is murder. Therefore, while starting the investigation, first of all, the cause of death, purpose, circumstances, etc. should be ascertained. What are the following? What are the causes of death? One is violent accidental or accidental death. Two is death without a retainer. Three is the deceased was not treated by a medical practitioner before death. Four is self-inflicted death. Criminal abortion, suicide, death by accidental poisoning, accidental death, death by knife, by fire from gun, by noose, by consumption of poisonous substance, etc. Death caused by criminal means, death in the course of rape or natural intercourse, death in prison or while serving a sentence, death due to infectious disease, death due to occupational disease, death etc. of a person by criminal act. Before commencing investigation in cases of murder and culpable homicide, it should be ascertained whether the person has died. Because sometimes even a person near death appears to be dead, and the identity of the deceased should be established. This work can be done through fingerprints, skeleton, family members, costumes, personality, dental examination, etc. of the deceased. Definition of culpable homicide and murder. 299 culpable homicide. Whoever causes death by doing an act with the intention of causing death or with the intention of causing such bodily injury as is likely to cause death, or with the knowledge that he is likely to such act to cause death, commits the offence of culpable homicide. What are its illustration? First is a lays sticks and turf over a pit with the intention of thereby causing death, or with the knowledge that death is likely to be, thereby death jet, believing the ground to be firm, treads on it, falls in and is killed. A had committed the offence of culpable homicide. A knows Z to be behind a bush. B does not know it. A intending to cause, or knowing it to be likely to cause Z's death, induces B to fire at the bush. B fires and kills Z. Here B may be guilty or of no offence, but A has committed the offence by culpable homicide. A, by shooting at a fowl with intent to kill and steal it, kills B, who is behind a bush. A, not knowing that he was there. Here, although he was doing an unlawful act, he was not guilty of culpable homicide, as he did not intend to kill B or to cause death by doing an act that he knew was likely to cause death. In its first explanation, a person who causes bodily injury to another who is laboring under a disorder, disease or bodily infirmity, and thereby accelerates the death of that other, shall be deemed to have caused his death. In second explanation, the way of death is caused by bodily injury. The person who causes such bodily injury shall be deemed to have caused the death, although by resorting to proper remedies and skillful treatment, the death might have been prevented. In this third explanation, the causing of the death of child in the mother's womb is not homicide, but it may amount to culpable homicide to cause the death of a living child if any part of that child had been brought forth, though the child may not have breathed or been completely born. Murder, except in the cases hereinafter accepted, culpable homicide is murder. If the act by such the death is caused is done with the intention of causing death, or secondly, if it is done with the intention of causing such bodily injury as the offender knows to be likely to cause the death of the person to whom the harm is caused, or thirdly, it is done with the intention of causing bodily injury to any person and the bodily injury intended to be inflicted is sufficient in the ordinary course of nature to cause death. Or fourthly, if the person committing the act knows that it is so eminently dangerous that it must, in all probability, cause death for such bodily injury as is likely to cause death, and commits such act without any excuse for incurring the risk of causing death or such injury as aforesaid. There are some illustrations regarding it. A shoots Jed with the intention of killing him. Jed dies in consequence. A commits murder. A, knowing that Jed is laboring under such a disease that a blow is likely to cause his death, strikes him with the intention of causing bodily injury. Jed dies in consequence of the blow. A is guilty of murder, although the blow might not have been sufficient in the ordinary course of nature to cause the death of a person in a sound state of health. But if A, not knowing that Jed is laboring under any disease, deals him such a blow as would not, in the ordinary course of nature, kill a person in a sound state of health, here A, although he may intend to cause bodily injury, is not guilty of murder if he did not intend to cause death or such bodily injury as in the ordinary course of nature would cause death. A intentionally gives Z a sword cut or club wound sufficient to cause the death of a man in the ordinary course of nature. Jed dies in consequence. Here A is guilty of murder, although he may not have intended to cause Jed's death. A, without any excuse, fires a loaded cannon into a crowd of persons and kills one of them. A is guilty of murder, although he may not have had a premeditated design to kill any particular individual. Contribution of the doctor in the investigation. The doctor can make an important contribution in the investigation of human slaughter and murder. The doctor pathologist can give his opinion on the basis of following points. In such cases, by reason of death, which wound is fatal, the voluntary actions of the wrongdoer after the injury, the condition of the wrongdoer at the time of the occurrence, the direction of application of force, struggle and defense signs, perception about rape, the type of weapon or instrument, whether the injury was before or after death, evidence as to degrading, evidence as to dragging or swaying of the body of the deceased, other signs or marks, whether the deceased has consumed any poisonous substance, time of death, etc. Procedure and method of investigation. There is no set rule for investigation in case of murder and culpable homicide. The procedure and method of investigation in such cases depend upon the facts and circumstances of each case. Normally in such cases, the investigating officer should follow the following procedure. Specific. One is taking photographs of any object or site on the spot as soon as it is reached there without touching them. Two is taking photographs of weapons, tools, blood stains, etc. Three is taking photographs of palm prints, fingerprints, thumbprints, footprints, etc. Four is drawing of the tire marks, tool marks, etc. Five is preparation of a map of the general condition of the spot action. In general, we can describe it noting the name of the complainant and the time of receipt of the information. Two is reaching the place of occurrence, and on reaching there, pay attention and be aware of the points like escape of the accused, person injured with flesh injuries, blood-stained clothes, etc. Nothing the restriction, nothing the registration numbers of the vehicles found in the vicinity of the accident spot. Maintaining a record of the time and exact location of the incident, interviewing the complainant in a cursory manner, obtaining information about person found at the spot, and leaving before the arrival of the investigating officer, and examining witnesses summarily for the purpose of preserving the evidence available at the spot, the prohibiting public traffic there for the purpose of preserving the evidence available at the spot, prohibiting public traffic there till the investigation is completed. To ascertain whether the person wronged is alive or dead. If he is alive, to take him to the hospital and make arrangements for his dying declaration statement to be recorded there. Arresting the offender immediately if he is on the spot. Obtaining information about the following facts. One is who found the person wronged, how he got there, what is his relation to him, who is the person who had seen the wrongdoer alive before the incident, where, when and with whom, who is the person aggrieved or wrong, who is an intimate friend of the wrongdoer, the names of the persons with whom the wrongdoer used to carry on trade, business, profession, etc., the condition of the wrongdoer before his death, whether he was ill, intoxicated, moody, angry, etc., while the offender came to the spot. What and how much property the wrongdoer had. The spending and drinking habits of the wrongdoer, the character and reputation of the wrongdoer, etc., taking fingerprints, etc., of the court, taking the blood of the wrongdoer to ascertain his blood group, drawing the blood of the offender to ascertain his blood group, seizing and stealing the clothes, shoes, etc. of both the wrongdoer and the criminal and sending them for criminal test, etc. What should not be done during investigation? The things mentioned above are positive guidance for the investigating officer. Here it is also appropriate to mention certain things which should not be done during the investigation. Do not talk, do not walk around the crime scene, as there is a danger of destroying the footprints, fingerprints, etc. recorded there. Do not allow unauthorized person to enter the place of occurrence. Do not touch, remove or alter any objects of the crime scene until the process of identification photography is done. Not lift any article of evidence unless authorized to do so. Do not give place to any wrong and imaginary notion regarding the incident. Keep the mind open for correct investigation. Do not forget to examine the body of the wrongdoer before taking off his clothes. If the wrongdoer is alive and able to speak, do not forget to get statements of his dying declaration recorded. Do not rush to the crime scene. Investigate peacefully, patiently, and impartially. Do not ignore the wounds, burn marks, etc. found on the body of the wrongdoer. Do not forget to record the name, address, etc. of the witnesses. Do not allow the witnesses to talk among themselves until their statements have been recorded. Do not create an impression that it is a case of suicide. Not to overlook the fact that the body of the deceased may be carried from one place to another, etc. Procedure of investigation in cases of suicide. Investigation in cases of suicide is not as complicated as it is in cases of murder and culpable homicide. Generally, the following points should be kept in mind during investigation in suicide cases. Preserving the scene of the incident and the evidence related thereto. Getting the aggrieved person tested, taking him to the hospital immediately. To inquire about all the things present at the spot, obtaining information in this regard if any intoxicant or poisonous substance has been consumed by him, ascertaining from the next of kin of the aggrieved person whether he used to make such threats before the incident, obtaining information about the position, status, difficulties, etc. of the aggrieved person, to ascertain whether the aggrieved or the deceased has left any note regarding his death, etc. It was not recorded in the court before the accused. Next we will discuss give the definition of rape and unnatural offences, explain the process of their investigation, what are the things that should be taken care of in connection with the investigation in cases of rape and unnatural sex, how is the investigation done in sexual matters, explain in detail. Among the crimes committed against the human body, rape and unnatural sex are the most heinous crimes. Investigation of such crimes is not as easy as that of other crimes. Investigation of such crimes is possible by skilled and expert persons. It is necessary for the officer investigating such crimes to have full information about the person who may be involved in such crimes. Knowledge of different classes of crime and sociology and psychology had also been considered necessary. For this, the crime for rape. The crime of rape can be committed with any woman, while the crime of unnatural sex is committed by and sexual unnatural sex intercourse. What is the definition of rape and unnatural sex? Important amendments have been made in the definition of rape by the Criminal Law Amendment Act 2013 and the Criminal Law Amendment Act 2018. Here is the revised provision. 375 rape. A man is said to commit rape if he penetrates his penis to any extent into the vagina, mouth, urethra or anus of a woman, or makes her to do so with him or any other person, or inserts to any extent any object or a part of the body not being the penis into the vagina, the urethra or anus of a woman, or makes her to do so with him or any other person, or manipulates any part of the body of a woman so as to cause penetration into the vagina, urethra, anus, or any part of body of such woman, or makes her to do so with him or any other person, or applies his mouth to the vagina, anus, urethra of a woman, or makes her to do so with him or any other person under these circumstances, falling under any of the following 7 descriptions. First, against her will. Second, without her consent. Third, with her consent, when her consent has been obtained by putting her or any person in whom she is interested in fear of death or of hurt. Fourth, with her consent when the man knows that he is not her husband and that her consent is given because she believes that he is another man to whom she is or believes herself to be lawfully married. Fifth, with her consent a man with her consent when at the time of giving such consent by reason of unsoundedness of mind or intoxication or the administration by him personally or through another of any stupefying or unwholesome substance, she is unable to understand the nature and consequences of that to which she gives consent. Sixth, with or without her consent when she is under 18 years of age. Seventh, when she is unable to communicate consent. In first explanation, for the purposes of this section, vagina shall also be included labia majora. In its second explanation, consent means an unequivocal voluntary agreement when the woman by words, gestures or any form of verbal or non-verbal communication communicates willingness to participate in the specific sexual act, provided that a woman who does not physically resist to the act of penetration shall not, by the reason only of that fact, be regarded as consenting to the sexual activity. In its first exceptions, 1a, the medical procedure or intervention shall not constitute rape. Exception 2, sexual intercourse or sexual acts by man with his own wife, the wife not being under 15 years of age, is not rape. 376, punishment for rape. Whoever accepts in the cases provided for in subsection 2 is commits rape shall be punished with rigorous imprisonment of either description for a term which shall not be less than 10 years, but which may extend to imprisonment for life and shall also be liable to fine. Whoever, one is being a police officer, commits rape within the limits of the police station to which such police officer is appointed, or in the premises of any station house, or on a woman in such police officer's custody, or in the custody of a police officer subordinate to such police officer, or being a public servant commits rape on women in such public servant's custody or in the custody of a public servant subordinate to such public servant, or being a member of the armed forces deployed in an area by the central or state government commits rape in such areas, or being on the management or on the staff of a jail, remand home or other place of custody established by or under any law for the time being in force or of a woman or children's institution commits rape on any inmate of such jail, remand home, place or institution, or being on the management or on the staff of a hospital commits rape on a woman in that hospital, or being a relative, guardian or teacher of, or a person in a position of trust or authority towards the woman commits rape on such woman, or commits rape during communal or sectarian violence, or commits rape on a woman knowing her to be pregnant, or commits rape on a woman who is under 16 years of age, or commits rape on a woman incapable of giving consent, or being a position of control or dominance over a woman, commits rape on such women, or commits rape on a woman suffering from mental or physical disability, or while committing rape causes grievous bodily harm or maims or disfigures or endangers the life of a woman, or commits rape repeatedly on the same woman, shall be punished with rigorous imprisonment for a term which shall not be less than 10 years, but which may extend to imprisonment for life, which shall mean imprisonment for the remainder of that person's natural life, and shall also be liable to fine in its explanation for the purposes of this subsection. One is armed forces, means the naval, military and air forces, and includes any member of the armed forces constituted under any law for the time being in force, including the paramilitary forces and an auxiliary forces that are under the control of the central government or the state government. Two is hospital, means the precincts of the hospital and includes the precincts of any institution for the reception and treatment of persons during convalescence or the person requiring medical attention or rehabilitation. These police officers shall have the same meaning as assigned to the expression police under the Police Act 1861 5 of 1861. Women or children's institution means an institution, whether called an orphanage or a home for neglected women or children, or widows' home, or an institution called by any other name which is established and maintained for the reception and care of women or children. Whoever commits rape on a woman under 16 years of age shall be punished with rigorous imprisonment for a term which shall not be less than 20 years, but which may extend to imprisonment for life, which shall mean imprisonment for the remainder of that person's natural life, and shall also be liable to fine, provided that such fine shall be just and reasonable to meet the medical expenses and rehabilitation of the victim, provided further that any fine imposed under this subsection shall be paid to the victim. 376. A. Punishment for causing death or resulting in persistent vegetative state of victim. Whoever commits an offence punishable under subsection 1 or subsection 2 of section 376, and in the course of such commission inflicts on injury, an injury which causes the death of the woman or causes the woman to be in a persistent vegetative state, shall be punished with rigorous imprisonment for a term which shall not be less than 20 years, but which may extend to imprisonment for life. It shall mean imprisonment for the remainder of that person's natural life or with death. 376 AB punishment for rape on women under 12 years of age. Whoever commits rape on women under 12 years of age shall be punished with rigorous imprisonment for a term which shall not be less than 20 years but which may extend to imprisonment for life, which shall mean imprisonment for the remainder of that person's natural life and with fine or with death, provided that such fine shall be just and reasonable to meet the medical expenses and rehabilitation of the victim, provided further that any fine imposed under this section shall be paid to the victim. 376b. Sexual intercourse by husband upon his wife during separation. Whoever had sexual intercourse with his own wife who is living separately, whether under a decree of separation or otherwise, without her consent, shall be punished with imprisonment of either description for a term which shall not be less than 2 years, but which may extend to 7 years, and shall also be liable to fine. In its explanation, in this section, sexual intercourse shall mean any of the acts mentioned in the clauses A to B of section 375. 376C. Sexual intercourse by person in authority. Whoever being in a position of authority or in a fiduciary relationship or a public servant or superintendent or manager of a jail, remand home or other place of custody established by or under any law for the time being, in force or a women's children's institution or on the management of a hospital or being on the staff of a hospital, abuses such position of fiduciary relationship to induce or seduce any woman either in custody or under his charge or present in the premises to have sexual intercourse with him. Such sexual intercourse not amounting to the offence of rape shall be punished with rigorous imprisonment of either prescription for a term which shall not be less than 5 years, but which may extend to 10 years and shall also be liable to fine. Explanation 1. In this section, sexual intercourse shall mean any of the acts mentioned in clauses A to B of section 375. Explanation 2. For the purposes of this section, explanation 1 to section 375 shall also be applicable. Explanation 3. Superintendent in relation to a jail, remand home or other place of custody or women's children's institution include a person holding any other office in such jail, remand home, place or institution by virtue of which such person can exercise any authority or control over its inmates. In its explanation 4, the expression the hospital and women's or children's institution shall respectively have the same meaning as in explanation to subsection 2 of section 376. 376b. Gang rape, where a woman is raped by one or more persons constituting a group or acting in furtherance of a common intention. Each of those persons shall be deemed to have committed the offence of rape and shall be punished with rigorous imprisonment for a term which shall not be less than 20 years, but which may extend to life, which shall mean imprisonment for the remainder of that person's natural life and with fine, provided that such fine shall be just and reasonable to meet the medical expenses and rehabilitation of the victim. Provided further that any fine imposed under this section shall be paid to the victim. 376d. A punishment for gang rape on women under 16 years of age. where a woman under 16 years of age is raped by one or more person constituting a group or acting in furtherance of a common intention, each of those persons shall be deemed to have committed the offence of rape and shall be punished with imprisonment for life, which shall mean imprisonment for the remainder of that person's natural life and with fine, provided that such fine shall be just and reasonable to meet the medical expenses and rehabilitation of the victim. Provided further that any fine imposed under this section shall be paid to the victim. 376 DV punishment for gang rape on women under 12 years of age. Where a woman under 12 years of age is raped by one or more persons constituting a group or acting in furtherance of a common intention, each of those persons shall be deemed to have committed the offence of rape and shall be punished with imprisonment for life, which shall mean imprisonment for the remainder of that person's natural life and with fine or with death, provided that such fine shall be just and reasonable to meet the medical expenses and rehabilitation of the victim. Provided further that any fine imposed under this section shall be paid to the victim. 376E punishment for repeat offence. Whoever has been previously convicted of an offence punishable under section 376 or section 376A or section 376B or section 376D or section 376DA or section 376DB and is subsequently convicted of an offence punishable under any of the shared sections shall be punished with imprisonment for life, which shall mean imprisonment for the remainder of that person's natural life or with death. Process and method of investigation. At the time of investigation in the crime of rape and unnatural sex, it is necessary to pay attention to the following points: the date and time of the occurrence, the nature of the offence, age of aggrieved person, the place of occurrence, whether light visibility, the physical and mental condition of aggrieved person, whether he or she was intoxicated, whether he or she was pregnant, marks of injury on his or her body, etc. The condition of the person's clothes, marks of tears or semen, etc. on them. The condition of the person's clothes, marks of tears or semen, etc. on them. Recording the statement of the aggrieved person, a woman policeman is expected to be present at such time. Methodology for attracting the distressed person. If the vehicle is used, full description of the vehicle, its condition inside, marks, etc. Corroboration of the statements of the aggrieved person. The character and reputation of the aggrieved person. Full particulars of the route of travel if the offence was committed while traveling. Full description of the suspect, his dress, etc. Statements of witnesses. Inquiring about the offender from the neighbors. Collecting physical evidence such as clothes, jewelry, shoes, slippers, blood, hair, 5 or fingerprints, semen stains, footprints, tire marks, soil, etc. The place and time of work of the offender. Articles found in the vehicle of the offender, such as newspapers, maps, etc. Articles found in the vehicles of the offender, newspapers or maps, etc. Full particulars of the offender along with color photographs, his statements, complete photographs, etc. of the place of occurrence. Specific process: sending the aggrieved woman to a hospital for examination and treatment along with a woman police officer. Examination of the aggrieved person by a medical practitioner, making a record of the injuries indicated on the body of the victim. sealing the clothes, etc. on the body of the victim and sending them for chemical test, recording in detail the statement of the aggrieved person, the possible motives for the incident such as malice, revenge, desire to conceive, etc. Sending the clothes, etc. of the criminal for chemical test, confiscation of the vehicle of the offenders, etc. Up to this, I thank all the brothers and sisters. I thank teachers and trainers. I thank professors and professionals. I thank ministers and managers. I thank respected doctors and directors. I thank honorable advocates, advertisers, administrative advisors, ministers and managers, the most honorable President President Modi. I heartily, cordially thank all of you for your presence today. It is really nice time, nice place, nice moments of life that we have spent in listening our holy Indian Constitution. Next, tomorrow we will discuss what are the qualities expected of an efficient investigation officer, explain, discuss the qualifications required for a skilled investigation. Till that, thanks.